Hi, I'm Steve Carlson of the Independence Party, wishing you a great Independence Day. On this day, our nation denounced long-set ways of arbitrary power and abuse, and corruption bred by power, and we established a system of government designed to protect the nation from these practices. But today, 237 years after all our sacrifice and dedicated purpose, it appears this promise is in grave danger. And so today I call on all Americans to ensure that we follow the promise of our Constitution and the aspirations of our Declaration against the abolition of our free system of laws and establishment of arbitrary government and absolute rule. The Democrats in office in Minnesota have established arbitrary and absolute rule and have defaced our free and fair elections and restricted our open discourse during the heat of election campaigns. I have challenged these corrupt practices in the 4th Congressional District of Minnesota. And this week I brought new evidence, including further evidence of fraud on the court by the DFL and their officials, the Secretary of State Mark Ritchie and Representative Betty McCollum. This evidence focuses on corrupt and self-serving use of email addresses of Minnesotans, including registered or likely voters, in order to promote the candidacy of just one person in 2012, Betty McCollum. This scheme followed the plan used by Ritchie himself in 2007, when he brought home 12,000 email addresses to give to his fundraisers for his own campaign, but then claimed the law bars him from allowing any candidate to use them, even though Minnesota's policy analysts correctly interpret the Minnesota law to uphold the presumption that they are public. So in 2012, when McCollum's primary opponent, Diane Lonegre, sought email addresses to communicate with voters, McCollum lashed out and demanded that the law be changed so that Lonegre couldn't have those addresses in the future, and took the opportunity to attack Lonegre's integrity. McCollum went further, calling on the state not to release any of the email addresses it collected. And this bar included the addresses I was offered and did pay for from Mark Ritchie's office. When Ritchie did respond and blocked the release of those email addresses to me in the heat of my campaign, Democratic judges have backed him with no legal basis, accepting false statements of Ritchie and his subordinates that the addresses had never been made available to any campaign, even Mark Ritchie's 2007 campaign. This is documented in a legislative auditor report from 2008, which those courts now have. And so on this July 4th, I read into the public record a summary of these facts and the federal lawsuit I have instituted and will vigorously prosecute to free Minnesota from DFL interference in free and fair elections, including the gender and race quotas Walter Mondale, Donald Fraser, and the entire DFL have implemented here and spread all across the nation. We can't have democratic government here if each state can't have free and fair elections for federal office. Plaintiff brings this motion based on the false and fraudulent submissions in this case of defendants, the state of Minnesota, and its Secretary of State Mark Ritchie and Gary Poser and Burt Black as set forth below, claiming that no emails in the public list have ever been disclosed to any candidate or campaign. But Exhibit A, the Legislative Auditor Report of January 2008, makes it explicit that Mark Ritchie himself is deceiving because he took those emails for his own campaign, to raise funds, no less. It is impossible that Black and Ritchie did not have knowledge that Ritchie himself had brought home 12,000 email addresses of likely contributors to his own campaign and turned them over to his campaign staff to use in his own fundraising. Black knew this because he was the Data Practices Compliance Officer for Ritchie and testified to the auditor on the matter, and yet stayed silent as he was, as the court finds, the in-house legal advisor for Mr. Ritchie, while Gary Poser, another Ritchie subordinate, falsely claimed that, for instance, at page 15 of the Memorandum to Dismiss, document 20, plaintiff assumes falsely defendants have not provided email address information from the SVRS to any political candidate. Poser affidavit at 6 to 8, italics in original. The actual affidavit of Poser, document 14, paragraph 8 at page 3, puts it differently, not what Mr. Hartshorn submitted. Quote, Upon information and belief, the Office of Secretary of State has not sold, distributed, or disclosed the email addresses in the SVRS system to any customer, including plaintiff or any other candidate for election," unquote. Before this legislative audit came to my attention through research after I watched Almanac, my evidence to oppose this affidavit was the statement of the Office of Secretary of State worker who not only in 2012 but also in 2010 told me the email addresses were available on a disk. But here is evidence that is irrefutable, because Mark Ritchie himself took 12,000 addresses from the office and shared them with his campaign staff for the Office of Secretary of State in 2008, and got caught only because 2 of the people on the list were Republicans. It is true that the legislative auditor cleared him of wrongdoing and possible action against him, but only by interpreting the Minnesota Data Practices Act in a way that Mark Ritchie and Burt Black now purport to eschew, to reject. If the court were to accept the position asserted in this case, that the law required Ritchie to not allow the emails in the SVRS to be used in a campaign, then he would be pleading guilty to what Tom Emmer charged him with in 2007. Combined with this, public reports of Betty McCollum's public call for the legislature to change the law so the state could not release the email, see Exhibit B. Finally, a comparison with the Florida statute on email shows there is clearly no bar to making all these email addresses public. And in light of the requirements of the First Amendment and Buckley versus Vallejo's admonition, quote, to assure the unfettered interchange of ideas for the bringing about of political and social changes desired by the people, unquote, citing Roth versus the United States from 1957, U.S. Supreme Court. Clearly, the DFL has to offer a stronger, more compelling interest in barring the use of these emails than they have shown so far. In point of fact, Minnesota's statute presuming the public nature of these emails is far broader than Florida's, and so it is totally partisan and out of place for the Democrats in Minnesota to hoard and manipulate these votes after the fracas in Florida, which led to the passage of HAVA, Help America Vote Act, which has in turn generated these email collections. Buckley defended the constitutionality of the Federal Elections Commission Act, FECA, of 1971 by stressing the, quote, vital governmental interests in relieving major party candidates from the rigors of soliciting private contributions, in not funding candidates who lack significant public support, and in eliminating reliance on large private contributions for funding of conventions and campaigns, while not invidiously discriminating against minor and new parties in violation of the Due Process Clause of the Fifth Amendment. New evidence, intrinsic fraud on the court by Minnesota defendants, and the interests of justice counsel that this case go on, and the dismissal, judgment, or order should be amended to allow the case to proceed on both counts. Based on the new evidence described in this motion, which indicates further misleading of the court on facts material to the manipulation and tactics by defendant Mark Ritchie using state-controlled email addresses of registered voters, amounting to intrinsic fraud, and the interest of justice, including but not limited to changes in the legislative session just ended sought by Betty McCollum as part of her 2012 request that would interfere with the free and fair and vigorous discussion via the medium of email as required by the First Amendment U.S. Constitution. And so plaintiff moves this court to amend and alter its judgment, to reverse its dismissal, and to allow the case to proceed to pretrial conference and opportunity for discovery and trial, and pretrial summary judgment motions. Defendants Mark Ritchie and Burt Black and Gary Poser, who also works for Ritchie, each of whom is an official of Minnesota's Secretary of State office, who is the chief elections official for the federal and all elections in the state, have, since the heat of the 2012 campaign, been engaged in spinning a web of deception about a material issue upon which this court decided against my temporary restraining order motion to release the email addresses to me during the election and dismiss the case. Defendants have been submitting conflicting assertions about whether or not they are legally bound by law to withhold the email addresses they collect under 201.0711 form, which provides, quote, the registration application may include the voter's email address, unquote. This is not in 201.91, either in the so-called public information list, or the restricted information list, or the master list, or the copy of the list to voter. As such, the requirement of 13.01 Minnesota Data Practices Act that the email addresses be public is not changed by anything in 201.91, because email addresses collected on the form are not even mentioned there. Compare change in 2013 to municipalities, which does not cover this HAVA practice. In addition, Betty McCollum herself has weighed in during the heat of her first primary campaign with Diane Lonegry, and then in my race with her in the general election to fight against her opponents by preventing them from getting email addresses. During her primary campaign with Diane Lonegry, she used the tactic both to attack her opponent seeking these email addresses and likely potential votes, and to deny them to Lonegry. Her latest efforts include a successful campaign to get the Minnesota legislature, where she served for many years, to block access, even for use in a campaign, to the municipal emails collected and protected for use under the Minnesota Data Practices Act, which has just been amended as she desired in the 2013 session, even as Lonegry's own DFL party dominated the government. An article August 9th in the 2012 election quotes McCollum talking to Minnesota Public Radio saying, quote, regardless of why Kevin Berglund, who is described as a Maplewood resident and a controversial figure in local politics, wants the email lists, the Minnesota legislature should change the law to foil future requests like this. More from the NPR article. McCollum publicly campaigned against the email addresses, saying the Minnesota state legislature should change laws, quote, to foil, unquote, requests for email addresses from municipalities. None of the entities from which Kevin Berglund sought emails implicated the HAVA vote, and the specific change to give privacy to emails submitted to get on a mailing list shows exactly what the legislature would have done and did not in order to deny access, which would violate the First Amendment, as discussed infra, to these email addresses voluntarily submitted via the application form by registering voters, who evidently expect to have correspondence concerning the elections, including with all the candidates and parties. Quote, so far, the other cities have been less cooperative than Roseville. St. Paul has yet to respond. Woodbury, Stillwater, Falcon Heights, and several others told Berglund his request would be time-consuming to fulfill. Some demanded Berglund pay thousands of dollars to cover the staff time before they went digging through their computer systems. They have yet to hear back from him, continues the NPR article. But they all acknowledge Berglund has a right to the data, with Maplewood as the one exception. Berglund is a Maplewood resident and a controversial figure in local politics. A group of city employees once took out a restraining order against Berglund, though a judge later threw the order out. City Clerk Karen Guilfoyle was one of those city employees, but she said that was not why she rejected Berglund's data request. She pointed instead to the privacy policy posted on the city's website. It says your email address will be kept confidential, and it will not be sold or disclosed to others or used for unsolicited mass mailings or spam, Guilfoyle said. Under the state law, that policy offers little protection. You can't have a privacy policy that's in violation of the state statute, said Don Gemberling, Secretary of the Minnesota Coalition of Government Information and the former head of IPAD. All that does is it's going to put them in a terrible bind because they're in violation of the statute. It's unclear what Berglund plans to do with the email addresses, but his requests target cities throughout Minnesota's 4th Congressional District. Berglund's wife, former Maplewood Mayor Diana Lonegre, is running for the U.S. House in Tuesday's DFL primary. Lonegre declined to say whether the requests are connected to her campaign. Incumbent DFL Congresswoman Betty McCollum holds the seat Lonegre is seeking. McCollum said regardless of why Berglund wants the email addresses, the Minnesota legislature should change the law to foil future requests like this. If I sign up to get a snow emergency alert, or if I sign up with a school district to get the lunch menu, I certainly didn't sign up for the school district or for the state or for my municipality to turn around and give my email addresses to anybody who wants it, McCollum said. The legislature has routinely amended the Data Practices Act over the last 30 years, usually to make more government data private, McCollum said, in view of the fact that the First Amendment requires that all statutes be interpreted to provide for full debate during the heat of the election. The finding of the state court judge who threw out the restraining order on release of these addresses must be attended to. As such, based on the Legislative Auditor's Report of 2008 called Secretary of State Mark Ritchie Investigation, Use of Contact Information, which showed Mark Ritchie himself receiving 12,000 emails he took home from the Secretary of State office and distributed to his Democrat colleagues to use to raise funds for his own campaign for Secretary of State itself, plaintiff moves that this court reopen the case and allow it to proceed. Mr. Ritchie has already changed his story on the issue of why he had to deny me use of those email addresses submitted to his office, from saying at first that he was bound by law and no one ever got these to use in a campaign, to holding he has explicit discretion to determine the use of these under IPAD decisions. Further, Florida Statute 668.6076 reads as follows: Public record status of email addresses. Agency website notice. Any agency defined in Statute 119.011 or legislative entity that operates a website and uses electronic mail shall post the following statement in a conspicuous location on its website. Under Florida law, email addresses are public records. If you do not want your email address released in response to a public records request, do not send electronic mail to this entity. Instead, contact this office by phone or in writing. Our statute has a broader presumption of public access than even the Florida statute, and this court should recognize and empower that.